Welcome, dear students. Today we are going to discuss extent and operation of Indian Penal Code along with the definition of crime and difference between crime and tort. The main objectives of this lecture are extent and operation of IPC, that is Indian Penal Code, definition of crime, essential ingredients of crime, difference between crime and tort. Before the enactment of Indian Penal Code, the British India was governed by the Muslim criminal law. After the advent of the British East India Company, some piecemeal legislations were introduced by the British to improve the administration of criminal justice in British India. An organized attempt was made by First and Second Law Commission to consolidate the criminal law. On the basis of the recommendation of the Second Law Commission, Indian Penal Code was enacted in 1861, which still governs the people of India. This law applies to the whole of India except the state of Jammu and Kashmir, which has its own penal law, and that's known as Rambir Penal Code. This is because of Article 370 of the Constitution of India. The territory of India is defined in Article 1, Subclause 3 of the Indian Constitution. According to this article, the Indian territory means A. Territories of the states, B. Union territories as mentioned in Schedule 1 of the Constitution, other territories which will be acquired and become part of the Indian Union. This law will apply to the territorial waters of India also. Therefore, if any offence is committed in the territorial waters of India, the accused can be prosecuted under Indian Penal Code. As per Section 2 of the Indian Penal Code, the offence committed within India means crime committed by a person national within the Indian territory. The territorial jurisdiction can be classified into two broad categories: A. Intra-territorial jurisdiction, B. Extra-territorial jurisdiction. The meaning of intra-territorial jurisdiction is when crime is committed within Indian territory as provided in Section 1 of the Indian Penal Code. The other jurisdiction is extra-territorial jurisdiction, which means any crime committed by Indian national outside Indian territory, provided that act is a crime within India and he can be punished by Indian courts. The Section 3 and 4 of the Indian Penal Code gives these jurisdictions. The Indian courts have been authorized by these two sections to try Indians if they commit any crime within or outside India. The Section 3 reads as under: any person liable by any Indian law to be tried for offence committed beyond India shall be dealt with according to the provisions of this code for any act committed beyond India in the same manner as if such act had been committed within India, unquote. Section 4 of the Indian Penal Code reads as under, I quote, the provisions of this code apply also to any offence committed by A. any citizen of India in any place without and beyond India, 2. any person on any ship or aircraft in India wherever it may be. Explanation added to the section says, in this section the word offence includes every act committed outside India which if committed in India would be punishable under this code, unquote. As far as Section 3 is concerned, the courts have the jurisdiction to try any offence committed beyond Indian territory provided the offender is subject to the Indian law. However, the operation of this section is subject to the application of Indian Extradition Act 1962. The code applies to all persons in India irrespective of their sex, color, religion, caste, etc. But only exception is the state of Jammu and Kashmir, which is governed by its own criminal law. The law applies to even those foreign nationals who are residing within the Indian territory. However, there are certain persons who are not subject to the jurisdiction of the code. These persons are immune from the jurisdiction of the code by virtue of the Constitution of India or by virtue of international law or conventions. Some of them are foreign sovereigns, President of India and Governor of a state, ambassadors and diplomats, etc. A universal principle of criminal law is that every country has jurisdiction over the waters which are adjacent to its land, and this is called maritime belt. The basic rule even accepted by the international law is that such jurisdiction extends to 12 nautical miles from the coast of that country. The earlier decisions of Indian courts have accepted this principle. Offences committed in Indian waters. The Section 4, subsection 2 of the Indian Penal Code deal with the admiralty jurisdiction, which says that if a person commits an offence on high seas, he can be punished in the following circumstances. Number 1, offences committed on the ship which are registered in India on high seas. 2, if a commission of the offence takes place on a foreign ship in Indian territorial waters. 3, offences committed by pirates. It has been also held by the courts that if an offence is committed on an Indian ship, IPC applies even if the ship is in high seas. This is based on the principle that ship is treated as on floating island and belongs to the country whose flag is hoisted on the ship. Similarly, if an offence is committed on a foreign ship which is not registered in India and the ship is within the territorial waters of India, the offender will be liable under IPC. However, if a foreigner commits an offence in high seas on a ship which is not registered in India, the person cannot be tried under IPC. Any act of piracy committed by pirates at any place in the sea can be arrested by the Indian authorities and punished under IPC. Piracy is same as is felony on the land. Piracy is a violation of international law and therefore a pirate is subject to arrest and punishment by all states. Offences committed in air. The development of the civil aviation in the world has given rise to the threat of criminal offences committed in air. India was not an exception to it. Crimes committed on aircrafts need to introduce the law to combat such offences. The problems in respect of hijacking, attack on the aircrafts resulted in the extending this jurisdiction in such cases also. The visible threat to life and property on board of an aircraft resulted into extending territorial jurisdiction of IPC in such cases also. At international level, first attempt to control these offences was made by enacting Tokyo Convention on offences committed on board aircraft. Offences committed outside India are committed by an individual on land, in water or in air. As per the offences committed anywhere within India can be tried and punished in India irrespective of the fact whether they have been committed on land, sea or in air. The offences committed outside India are dealt in section 3 and 4 of the IPC. Therefore, if a person kills a man in Uganda, he can be tried and punished in India. If a person commits an offence outside India and that act was not an offence in that country, he can be punished in India if the act is an offence in India. Now, second important issue is that how to define the crime. What is crime? This is a question which is often asked from the students of law. Different thinkers, criminologists have given different definitions of crime. But before we answer this question, we must have an idea about definition of law. Traditionally, we believe that a law is a command from the political or sovereign supreme to his political inferiors. In present day political setup, this is a command given by the state, that is legislature, to its subjects or people. The legislature consists of elected representatives of the people. Therefore, one can say that crime is disobedience of the laws framed by the state through legislature. But does it mean that disobedience of all laws can be treated as crime? The answer is no. Therefore, the crime is something different from disobedience of laws. Precisely, it can be said that crime is a wrong which is forbidden by moral values of the society as well. Therefore, the act of murder and dacoity can be treated as a crime, whereas violation of a contract is not a crime but a civil wrong. But again, morality and morals are flexible terms, and they may change with the change of society. An act may be morally wrong in one society but not in the other society. Therefore, moral values change with change of society, whereas crime does not change. There are a number of examples to prove my point. Say, for example, polygamy was not a wrong in early Indian society, but now it is not allowed under the law. Similarly, until recent times, sati was not wrong in India, but now it is an offence under IPC. Blackstone defines crime as an act committed in violation of a public law, forbidding or commending it. Now, what is public law? Various scholars like Austin defines public law identical to the constitutional law. Austin defines crime as a wrong which is punished at the discretion of the injured party and his representatives in a civil jury. A wrong which is pursued by the sovereign or his subordinates is a crime. Professor Kenny, while defining crime, says crime is a wrong whose sanction is punitive and is in no way remissible by any private person but is remissible by the Crown alone. Russell explains that the criminal offences are in fact creation of criminal policies adopted by a society from time to time. The society which adopts these principles is always powerful in nature and control the society. But a student of criminal law has to understand the definition of crime differently. It is not possible to adopt such a definition of crime which is accepted by every society at every time, but an attempt should be made to define an act as a crime which is acceptable to the most people always. The definition of crime provided by various jurists may not be acceptable to a student of criminal law in modern days because the nature, extent and quality of the crime has changed with the change in social values. For example, dowry was not a crime in early stages of human development, but now it is a crime. With the changed values in the society and scientific techniques, the concept of crime has undergone a change. In old days, we had some specific type of crimes like property offences, offences against body or state, etc. But now the nature of crimes have changed and we have cyber crimes, white collar crimes, juvenile crimes, terrorism, to name few. Therefore, the criminal law needs to deal with these crimes in a different way. The modern approach to crime is functional approach towards crime. It lays down to approach a crime and it is controlled in a positive and negative terms. The Wolfden Committee report in 1958 has emphasized to adopt this approach to define a crime. It says that the main purpose of criminal law is to preserve public order and decency, to preserve the citizen from any offence or injury, to safeguard the subject from exploitation and corruption. It also gives the negative aspect of the criminal law when the report says that the object and purpose of law is not to intervene in the private lives of citizens. After giving the short background of the purpose of criminal law and defining crime, it is now necessary to explain what are essential elements of crime. The following are the essential elements which constitute an act as a crime. Number 1, human being. If one studies the development of the criminal law, one finds that in early stages of human development, the crime was a wrong being committed or omitted by anything which included even the animals and inanimate objects. There are numerous instances when cows, pigs and horses were punished for causing any harm to the human beings. Even in certain cases, the appeal would be made against a judgment passed by a court against a beast. In Middle Ages, the animal trials were very common. Not only animals, even the inanimate objects like stone, trees or pieces of iron were tried and punished. Under the English law, these objects were forfeited as dividend. This rule was abolished in England in the year 1846. Even it is interesting that the intention of the wrongdoer was never considered relevant at the time of trial, but now the situation is altogether different. At present, it is essential that a wrong should be done by a human being who is capable of understanding the consequences of his act. Huda has said that a wrong shall be a crime only if it is done by a human being who is under legal obligation to do an act in a particular way. This means that the law should have forbidden an act which the offender has done. Needless to mention here that ancient Indian criminal law was not following the English law where the animals and inanimate objects were punished. The reason was that the Indian law was well versed with the idea of mens rea in a criminal charge. Therefore, to constitute a crime, there should be a human being who is capable of understanding his act. For quite some time, it was believed that inanimate objects or artificial persons cannot be punished for criminal or wrong acts, but now it is well settled law that even corporations can be punished for quasi-criminal acts and fines could be imposed on them. It is also necessary that a human being should be under a legal obligation to do an act as per the law. That is why an insane person is exonerated from criminal liability. Second essential ingredient is mens rea. In order to establish the liability of a person, it is to be established that he had a guilty mind at the time of commission of offence. The whole criminal law is based on the English law maxim, Actus non facet reum nisi mensit rea. This maxim, when applied, indicates the state of mind of the accused at the time of commission of offence. Mens rea, or mental condition of the person at the time of commission of offence, is the motive force behind the criminal law. The concept of mens rea is well explained in the famous cases of R versus Prince and R versus Tolson. The third essential ingredient of the crime is physical act, or actus reus. Russell has said that the physical act is a must for commission of a crime. Mere intention cannot make a person liable unless there is a physical act or actus reus. Actus reus is a physical conduct or act of the wrongdoer. Actus reus or physical act can be defined as a physical result of human conduct. The mens rea and actus reus are interrelated with each other and are necessary to make an act as a crime. Now, let us discuss what is the difference between crime and tort. There is definitely a difference between crime and tort. It is said that tort is a civil wrong, whereas the crime is a criminal wrong. The remedy for tort is in terms of damages, whereas the remedy for crime is in terms of punishment. The tort is a private wrong and the crime is a public wrong, and society at large is affected by the crime. The crime and tort are dealt with different tribunals, where the tort is decided by a civil court and the crime is decided by a criminal court. Dear students, I hope that you have understood the different aspects of the law of crimes today, and this subject will benefit you. Hope to see you in next section. Thank you.